My name's Dominic Mackenzie and I'm the Head of Private Client at Ison Harrison Solicitors. A deputyship is the mechanism under which the court and a person appointed by the court can deal with the affairs of a person who lacks capacity. It would usually be the case that a deputyship is necessary where there is no power of attorney in place or put into place whilst the person had capacity. We are more than happy to assist you with an application to the Court of Protection. First and foremost, you would need a medical report in the prescribed form confirming that the person in question is no longer capable of making decisions themselves. Subject to which type of deputyship order you're applying for, there would then be various supplementary pages and forms to complete. Those would be submitted to the court would then issue the papers, and then there would be various notice requirements serving notice upon the person in question and upon specified relatives. Again, we can help with all of that. It is possible to make an application to the Court of Protection for an emergency order. However, we would stress that in our experience, the court will only treat an application as an emergency if it really is a true emergency, and often that can be, it has to be a life and death related matter before the court will consider it as an emergency. If they do consider it as an emergency, then they have a dedicated team who will assist with the processing of the application and the putting of the application before the court as soon as possible, so things can be dealt with in an emergency. Once again, the important thing is to get the wheels in motion and to get the papers before the court as soon as possible. A deputy has the duty to act in the best interests of the person to whom the application relates or who they're acting for. They should have regard to the rules of the Court of Protection, any conditions or restrictions in the deputyship order itself, any directions issued by the Court of Protection. They should overall have a view and an understanding of the Mental Capacity Act 2005 and its code of practice, but the underlying principle is that they should act in the best interests of the donor. We would say that you must keep a record of your actions as a deputy, particularly financial transactions. The Court of Protection may ask for reports to be filed detailing all of your actions taken. We would also suggest that you keep a written record of decisions that you make relating to a person's property and affairs, and also the health and welfare type decisions that you may make, because you never know when the Court of Protection might ask for that information, and it would only cause problems if you didn't have that information to hand. If a person is mentally incapable and either does have a will but that will needs to be changed, or they don't have a will at all, then it is possible to apply to the court for what's called a statutory will. And if that application is successful, then the court will authorise the making of a will on behalf of the incapacitated person. If you'd like any further information, or if you'd like to discuss any of the matters that I've discussed today further, then please call me on 0113 284 5000.